Hello and welcome to part three of this summary of our 13th annual employment law breakfast briefing. Um, for those of you who have made it through parts one and two, well, you're nearly there. You've nearly completed the box set. And for those of you who have hopped in just to this section of it, my name is Ian McRae. I'm an employment partner at Field Seymour Parks. And the purpose of these sessions is to give you a high-level overview of some of the changes that are being proposed in employment law. So as I say, this is part three. So what are we dealing with in this section? Well, we're going to start talking about 0 hours contracts. Why might they become less attractive to businesses? Why will trade unions matter to all employers? We've got some changes to trade union legislation which may increase their importance. Got some changes to employment law enforcement. And then we've got what else do I need to know, which covers a number of other changes that I couldn't fit under any of other headings, but I thought you still needed to know about them. So let's crack on. Let's talk about 0 hours contracts. Well, why are they potentially becoming less attractive? Well, so some of you, if you've been reading the press, you will see that there is, as of yet, no plan for an outright ban on 0 hours contracts. We equally don't have concrete proposals as of yet for a single employment status, which might have almost eliminated 0 hour contracts by the back door. And indeed, the changes which I talked about this time last year that were proposed by the Conservative government about a right to request a more predictable contract have been binned by the Labour government. So you read all of that, you might think, well, what's the fuss about? Well, the issue is in the Employment Rights Bill, there's some quite complex new provisions that will give new rights to those people on 0 hour contracts and indeed others as well, that might make these contracts more difficult to manage and less attractive to businesses going forward. So at the heart of that is a duty to offer guaranteed hours. So this will apply for employees who are on a 0 hours contract or a low hour contract where they're working in excess of those hours. Now, we don't know what a low hour contract will be as of yet, which is somewhat fundamental. Doesn't currently apply to agency workers, but that may well change in due course. If the employer reasonably considers that an employee might be entitled to this offer of guaranteed hours in due course, they need to give them a notice of those rights. And then at the end of every reference period worked, which might be 12 weeks, we wait to find out, but that's the suggestion currently, they will have to make an offer to them of a guaranteed hours contract, reflecting the hours they regularly worked in that prior reference period. It is an ongoing obligation. So if the employee does not accept the offer and continues on a 0 hours or low hour contract that still meets the requirements of this section, every reference period you would need to be making an offer to them. You can't vary the terms if it's going to be done under the same contract, and if not, if it's a new contract, it can't be less favorable. The default is that it will be an offer of a permanent contract, although there will be some circumstances where a fixed term contract will be permitted. A big risk with this, I think, is overstaffing. So if you have a large 0 hour or low hour contract workforce, you make them all offers of guaranteed hours after 12 weeks. They all accept, or a lot of them do, and your work level for the next reference period, next period of time is reduced. You may end up with too many employees. And obviously, when that's combined with day one unfair dismissal rights, which I talked about in the second part of this session, then that could become quite an onerous thing to manage. Remedies, where you can get a declaration from a tribunal that you should have received an offer, and you can get just an equitable compensation subject to some form of cap. Equally, if you are subjected to a detriment or you've been dismissed, then because there is an awareness that you have a right to this offer, or because you've accepted or rejected an offer, again, that could give rise to a claim as well and could be automatically unfair. The second change, which is linked but could, depending upon the detail, have a even wider impact is there are 3 new rights in respect of shift workers being proposed, and they are, in simple terms, a right to a reasonable notice of shifts, a right to reasonable notice of shift changes or cancellations, and a right to payment for cancelled or curtailed shifts when that is done so at short notice, unless there are specified circumstances. Now, those employees who will qualify for this protection are again those 0 hours and low hours contracts, but it will also cover shift workers with a variable pattern. So that could be an employee who is required to work shifts under their contract, but it doesn't say exactly what they are. There is the suggestion that there might be a potential maximum salary or maximum hours type limit that would take some of those shift workers out of scope, and the government has said that the focus is on the low paid and those on unpredictable working patterns. So your well paid engineer who is on shift patterns could be out of scope once the detail is revealed, but we wait to see. What will cancellation payments be? Well, we don't know. They are meant to be proportionate, so presumably they will have some reference to the value of the shift to the employee and the amount of notice given. Again, declarations of non-compliance available from tribunals and just and equitable financial compensation. And again, protection from being subjected to detriment for refusing to work if you have a reasonable belief that the required notice has not yet been given. Lots of details still needed on that, particularly what short notice means, what specified circumstances mean, but one to watch. So what do you want to do about this now? Well, we do need the detail to understand the full impact, but I would certainly be looking at my workforce. I'd be looking at those 0 hours or those who are on very low hours of guaranteed work. I'd be looking at their 12-week averages. I'd be starting to think about what might the impact be if that was a permanent state of affairs. I'd probably be particularly concerned about seasonal fluctuations, where you could have very high level work for 12 weeks and then nothing. Depending upon the impact and depending upon those final regulations, I'd be looking at whether there were any alternative models that would help service work in a easier way. And equally, if you do have shift workers and there are steps you can take now that will improve shift scheduling, improve communication and certainty about it, that is likely to be wise in advance of these changes coming in. So something slightly different now, talking about trade unions. So the changes that are proposed in the Employment Rights Bill in respect of employment law have received a lot of widespread press. There are also sweeping changes to the legislation concerning trade unions that don't have got quite the same amount of acknowledgement. Now, unions will have different impacts on different employers. So there'll be some people listening to this session who will recognize trade unions formally and will collectively bargain with them on things such as pay, hours, and holidays. And there will be other people, other employers listening to this who have low levels of trade union membership in their organization and indeed don't recognize a union at all. Well, there are 2 changes that in particular will impact on all employers. So there is going to be a right to a statement of trade union rights. We understand that this is likely to be required to be issued at the same time as a Section 1 statement, which is normally contained within employment contracts and issued at the start of employment. But it might also be required at other times in the employment relationship. And it's likely to cover things such as the right to join a union, the right not to be subjected to detriment or treated less favorably as a result. And that will apply even if you don't recognize unions in your workforce. You will still have to give that statement to all of your employees. Equally, even if you don't recognize unions, you may need to give them right to access your workplace. So there is going to be a process for this. There'll be some form of access request from a union. There'll be a response period, and if necessary, a negotiation period. And if none of that works, it will go to the Central Arbitration Committee, the CAC, who deal with union matters such as this. And again, this will apply even if you do not recognize a union. You may have to give access to your workplace for them to meet with potential members, explain the benefits of union membership or indeed recognition. We've also got some reduced requirements to formally apply for that recognition for collective bargaining. Currently, if they want, unions want to make an application to the CAC, they need to demonstrate there are at least 10% union members in the bargaining unit, i.e. the group of employees they want to represent. That's going to be reduced to between 2 and 10%, so it'll drop. And they also need to demonstrate currently that the majority of people in that bargaining unit are likely to favour formal union recognition. That will also be removed. That will no longer be required. So in theory, applications can be made when only a very small percentage of unions, employees in the unit are union members. However, there will need to be, or is likely to need to be, a ballot for approval of union recognition. Currently, there is a requirement that not only a majority of people are in favour, but also that 40% of all employees participate in that vote. That will be removed. It will just be on a bare majority of those who take part. Trade union officials and learning representatives in recognised employers already have a right to paid time off. They will now have a right to facilities to be provided by the employer as well, which could include meeting spaces, telephones, access to email, notice board, things like that. And those rights for paid time off and access to facilities will also be extended to trade union equality representatives, again, in recognised workplaces. Will we see more strikes? Short answer is I don't know. The reality is industrial action is primarily driven by economic and industrial conditions rather than legislation. However, we do have some changes to the law concerning when industrial action is lawful. Some of you may recall the strike minimum service levels that were brought in by the Conservatives, which in very simple terms provided that a minimum service level needed to be maintained in certain sectors such as health, transport, education, fire and rescue, border control. And if those weren't maintained, then a strike or industrial action would be unlawful. Those are to be repealed by the Labour government. Also, restrictions on industrial ballots are changing. So currently there's a 50% participation in industrial action vote requirement. So again, not just a simple majority, you need to have a certain level of participation. That will be removed. It will just be a simple majority. Similar thing in important public services. You also had this additional requirement that 40% of the total workforce were in favour. That again is removed. So again, we go back even in important public services to a simple majority of those who engage in the vote. Information to ballot members, ballot papers are all slightly simplified, likely to be 7 days notice of industrial action rather than 14 days. Some of the requirements on picketing are going to be removed, and protection from detriment and dismissal for lawful industrial action will also be improved as well. So action points, one to watch. Essentially, we need to wait to see what the detail is, but you need to be prepared to give that written statement of rights to all employees. You need to be prepared to give access to unions. And one thing you might want to think about currently is if you have a heavy number of union members in your workplace, but you do not recognize a union, you might want to consider voluntary recognition rather than waiting for them to apply via the CAC for statutory recognition. Various advantages of voluntary recognition. You can think about and choose the unions you want for certain bargaining units. You might have greater control and flexibility over the negotiation model and logistics. You can avoid the deadlines and disruption of a statutory process, and you may even be able to introduce some dispute resolution procedures that can help prevent industrial action in the first place. Employment law enforcement. Few things to quickly highlight here. We're looking at a potential 6-month deadline for claims, subject to adjustment for the ACAS early conciliation process. As you may well be aware, it is currently 3 months subject to those adjustments, so that will be extended out. We're going to have a new Fair Work Agency, which is going to combine some of the powers of existing bodies, plus an additional power to help enforce holiday pay issues. And they've got some associated new powers as well. And we've also got some changes relating to immigration, some enhancement of the potential penalties that can apply there as well. Right, final things to be aware of. Umbrella companies. So some of you will be familiar with these, some of you won't. But the idea is that a legitimate umbrella company will employ workers, will ensure that they deduct their tax and national insurance, will ensure there is compliance, and will then essentially supply or contract to supply those workers to an agency or an end client. The government is concerned that they are being used as a means of avoiding tax liability. And a bit similar to what they did with the off-payroll rules, they're looking to move the tax liabilities up the sort of contractual chain to the agency or end client, and that's going to apply from the 6th of April 2026. If you're using umbrella companies, that's one you definitely need to pay attention to. The Economic Crime and Corporate Transparency Act 2023, we will shortly be doing a separate webinar on this topic, but there will be from the 1st of September 2025 for large companies a potential criminal liability if they failure to prevent fraud by an associated person, which can include a subsidiary or indeed an employee of the organisation. The defence to it is to show they've got reasonable procedures in place to prevent that fraud, or that it's not reasonable in all the circumstances to have expected them to have those procedures in place. Lots of things that need to be considered there. Put some of them on the slide: top level commitment, risk assessment, training, policies, prevention procedures, due diligence, monitoring, review. But we will cover that all in our separate webinar on the topic, and if you subscribe to our updates, we'll make sure you get an invite to that in due course. But if you're a large employer, you need to, or large company more accurately, you need to make sure that you have process in place before the 1st of September. A few other things to notice: statutory sick pay. The waiting days that currently apply are to be eliminated, so potentially getting statutory sick pay from day 1 rather than normally day 4. Those who earn less than the lower earnings limit will also be entitled to some form of statutory sick pay. We wait to hear exactly how much. Tips and gratuities, talked about this last year, and some increased obligations to consult about tips policies, periods of time for review, and to ensure that there is engagement in that consultation and a summary of the views used to create that policy are available. And then public sector outsourcing. There's a plan here to sort of prevent two-tier employment when services are outsourced from the public sector. So as some of you may be aware, as and when there is an outsourcing, it is likely that the TUPE regulations will apply, meaning that those employees who transfer out to a private sector company have their terms and conditions protected. These new regulations might mean that not only are those employees protected, but the other employees in that private sector company may have to have their rights and benefits brought up to the same level of those public sector workers. We wait to see exactly what that means, but it is one to watch, particularly if you are regularly providing services into the public sector. It could, in theory, potentially increase the cost of those contracts considerably, because you're not only factoring in the employees that you are inheriting, but there might be an impact on the rest of your workforce as well. So, if you have made it to the end of part 3, having watched part 1 and 2, well done, congratulations. It is obviously a very quick, high-level summary. Please do take legal advice. If you've got any questions, on any aspect of anything we've covered in any of these 3 parts, then please do get in touch and we would be happy to try and help. We will be producing further content as and when some of the details of these changes come into effect. If you contact me, I can make sure you're signed up so you receive notification of future webinars, of updates and further future events. And equally, my details are on the slide if you have any questions at all. Thank you very much.